My name is John Johnson. I'm the third because my family keeps naming people the same thing. So the suffix is really important to me. I'm a regulatory attorney who practices in the food and drug space. I love FDA, I love history, and I love the intersection of how that history influences our regulatory climate today and into the future. I like Legos a lot. You're going to see that in the presentation as we think about the law. And then kind of my dating question, my favorite court case, and this gets asked always in law school, what's your favorite court case and stuff? So a food can be adulterated because it's otherwise unfit for food. It's still safe. It's not decomposed, but man, it's gross. It's just gross. And so once FDA tried to seize a product of asparagus because it was too woody, and so the defendant was able to convince the judge, who was a carnivore eater, he confesses, to eat the asparagus, and over the course of 3 days, he successfully eats it and decides the food is not too woody and sides for the defendant and against FDA. So one of the things we're going to kind of talk about today is this obligation about supply chains. How do you know you're bringing in safe food, those obligations in your supply chain? Safe food is important. We're in here because of the critical function of food in the supply chain. It's part of our quality and something we care about. What's new about it is we now have these federal regulations. And so I'm going to start off as the attorney to kind of give that context of what is the law. Sussie's going to really come in and say, okay, how is this big picture law really in the regulations and the challenges that we're seeing? And we're going to talk about kind of solutions, because in the end of the day, looking at a piece of paper, which is really kind of the perspective I'm going to first bring, well, what does this mean except for a lot of headaches and a lot of paperwork, and how do I get through it? Because if you don't have that type of solution, if you don't know how you're going to actually have a program that is meaningful, one, you're not going to be in compliance with the law, but also that you're not going to have good commercial relationships as suppliers up and down the stream are putting pressure to make sure there is compliance and the like. So we're going to start with that kind of framework, and that's what I'm bringing in. So there's really kind of three objectives I'm going to bring in my little piece. We need to understand how FDA regulates food import. Battered throughout are also pictures from FDA's history. That's the Port of Baltimore, circa 1980s. I think that's actually Newark, where they're testing products at the FDA mobile lab, circa 1970s. But how does FDA regulate food imports? Because FSVP fits into that regulatory regime where you're going to be interacting with FDA. Kind of high level, what is FSVP? How does it fit within this regime? And then how is FDA implementing it? We can look at these papers and these documents and people can say all these words, but how is actually FDA going about it? So you can understand what questions are you going to be facing from the Food and Drug Administration as you're thinking about your solutions and moving forward. So when we think about FDA's regulation over food imports, I want people to think about Legos. I love Legos. They're different building blocks that are being put together, and FSVP is just one component in it. FDA has sampling and testing of food products, which people may have been experiencing before in the past. FDA has facility inspections that they're doing and several other tools. So FSVP is one of these newest tools, and how it integrates helps to think how FDA thinks about it and how the regulators are going to interface with you as you build your program. So the traditional approach, how FDA has regulated food, dates back actually to 1899. The law has been pretty constant. FDA with imports, if you've had to experience an FDA import exam, can stop any shipment for any reason and examine it for whatever it wants, as long as it wants. They have a little bit more powers than customs. But the owner of the consignee of those goods has a right to introduce testimony as to its compliance. And based on that examination or otherwise, FDA can issue an import refusal. So FDA, as long as it convinces itself that your product doesn't look in compliance, it can keep it out of the US market. They don't have to go to court. They don't have to convince anyone other than themselves, which is a pretty, I will say awesome, is a pretty big power that they have. If it looks non-compliant, they can say, get out of the market. You're not even allowed in the US. Something that's important to think about, though, is this is an MREM action. Yay, attorneys in Latin. MREM means it's an action against the thing. If this Lego police officer is FDA, he's literally yelling at these croissants. Croissants, you are in violation of the law. And let me tell you why. Now, the importer comes in to defend our croissants, but it's all about the croissants. And as we're going to kind of use an analogy as we talk through this, James is our foreign supplier of croissants, and Jennifer and I are two different importers of them. And so FDA is looking at them, making sure they're in compliance. Notably, they're not looking at Jennifer and I yet. So, kind of just some high-level reflections that we've already kind of hit on is it's about the food and its compliance. It's not about what importers are doing. FDA may never, ever show up in an importer's office. They go to the port, they're at warehouses, they sample it, but they never come to the importer offices. Also, under this part of the law, there's no legal requirement of due diligence. How do you know that you're importing safe food? At this point, prior to FSMA, the law says, I don't care. You just better import safe food. And if you don't, we'll stop it, but there's no legally mandated due diligence that you need to follow. Well, as many of us are aware, 2011 comes a Food Safety Modernization Act, where the Congress updates the law to say, yeah, there's some weaknesses in our food safety laws, and we need to update them. In imports, there are a lot of updates. One of them is more foreign facility inspections. 2010, the year before FSMA, FDA did 350. In the law, Congress actually told them to do 4,800, and FDA just started laughing a lot because Congress didn't give them any money to do any of that. But they're doing about 1,200. So that is a big jump from where it was. And one of the big things that with FSMA as it requires imports is this foreign supplier verification, where there is now new legal requirements put on the importer which had nothing before. So remember, if you were importing food, it had to be safe, it had to be in compliance, but how you chose that foreign supplier and how did you know that you were getting compliant food, from a legal standpoint, was irrelevant. There wasn't that due diligence requirement until we get the food safety, until we get FSVP. And so, big picture, what is it? It's now holding the importer legally responsible by having a process that they must follow to review and approve their suppliers. So Jennifer and I now both need to look at James and ask him a series of questions to know how he's making his croissants that we want to import, and what are his controls, and how do we know that we're going to get a safe product. FDA summarizes it in these words: foods imported into the United States has been produced in the manner that meets the applicable U.S. food safety standards. So with this new obligation on importers, there was also a new obligation on U.S. manufacturers of food to say that how they made the food matters. So how many in this room are familiar with HACCP? All right, who remembers where HACCP came from? Shout it out, someone. NASA. Your hand was up. NASA. And why did Pillsbury invent it?
I'm sure the astronauts had a big safe food supply.
Yeah, no one wants to see an astronaut puking in space. It looks really bad in a Cold War.
And a spacesuit.
And a spacesuit. It causes a lot of problems. But it was this concept of food safety and the like. Well, that wasn't, except for juice and seafood, where FDA legally was creative, there wasn't a requirement on any food manufacturer in the US to have HACCP in these food safety preventive models. There wasn't a legal requirement. FSMA changed that. And FSVP is a parallel to that. And so through FSVP, we're now approving our suppliers. And so what matters is how we get there. FDA is now reviewing their processes. And so what are the basics that Sussie's really going to get into is this idea that you understand the food safety hazards, you understand how your supplier is going to control them. What's their compliance history like? Some people look really good on paper. Enron was a wonderful company on paper. And yet in practice didn't do some things really well. So you have to look at your supplier's compliance history and you put those together to say, is this someone who I'm willing to buy food from? Do I believe that they're able to produce food to the same safety standards as US manufacturers? And if you say yes, then how do I verify that they're going to do what they say they're going to do and still get that safe food? And so then you select a verification process, whether it's on-site audits or relying on a third party who's done an on-site audit, product testing, reviewing food safety records, or the proverbial other that is appropriate in the circumstances. And if there's a problem, you have to do corrective actions. Now, this is the paradigm. There are lots of exceptions, and it's important to understand the exceptions, whether you're importing a food with no food safety hazards or a food that is not covered by FSVP, so say seafood or juice. But it's all based off of this. Or if you're importing food from countries officially recognized systems. Canada has modified rules. But this is the basic. It is a legally mandated due diligence. So don't get lost in the language. It's a due diligence requirement that you need to fulfill, document and fulfill. So one comment I just want to do a quick aside on, because it comes up a lot, is, well, who's the importer? Importer is a dangerous word in the import community because it's the proverbial, well, it depends on who you ask. There's a commercial sense of who is an importer. U.S. Customs and Border Protection has an opinion on who's the importer. They even allow foreign entities to be an importer. So FDA decides, well, we should define importer too. And their definition is different than many others. The importer means the U.S. owner or consignee of an article, a food that's being offered for import into the United States. So we say, oh, well, I know that word, U.S. owner and consignee. Those are pretty common trade words. I know who that is. Well, it's a term of art here, actually. Because you say consignee, okay, I have a virtual business, and I send all my goods to a 3PL. Well, they're a consignee. I wonder if they have an FSVP obligation. Well, that sucks for the 3PL. As long as it's not me, right? Well, no, FDA set and defined what does U.S. owner and consignee mean. It's the person in the United States. So if you have that foreign importer record, Canadian firm is the U.S. importer of record, they can't be the FSVP importer, because the entity must be in the United States, and at the time of entry either owns the food, has purchased the food, or has agreed to purchase the food. So our 3PL, who is a consignee in common sense, couldn't be the FSVP importer because they haven't agreed to purchase this food, or have purchased the food, or either own it. So it's someone else. So it's important to think about your supply chain and say, who has this legal obligation? And is it me? Because if it's me, I need to make sure I'm doing the right things. And if it's not me, I better make sure that whoever has that obligation is doing what they need to do. Because as we talk about the enforcement side of it, you could find a situation where if they're not in compliance, it kills your supply chain. So we always want to be clear on who is the FSVP importer. And anyone who's dealt with larger operations, and particularly if you want to play with them, they generally make you sign as part of your onboarding agreements. So say your large national retailers, that they will never be the FSVP importer. They will not take on that obligation because they're worried about that, and they want that supply chain control. So we have this regime. We have this new law that says you have to have a due diligence on how you import food, and the due diligence consideration is food safety. And you have these steps. Okay, that's nice. How is this enforced? So being a parent with children, if you just threaten them and there's no enforcement mechanism, they sometimes blow me off. Similarly, how is the federal government enforcing this new requirement? What are the consequences if you don't comply, if importers don't comply? Well, there's two. There are two big ones, but one that we're really going to focus on. One is that import refusal. You try and bring something in and you have a non-compliant FSVP. I'm the bad actor always in this example. Jennifer's compliant. So I've blown off FSVP, done none of it. FDA inspected me, says, John, you suck. They say it just like that. Any shipment I try to bring in of those croissants from James are going to be refused. Not allowed in. Not because they're perfectly safe and everything, but because I haven't done my due diligence, it's not allowed to come in. A separate batch that he makes for Jennifer still can come in because she has a wonderfully compliant FSVP. So this obligation, which may seem tedious and such, has real quick consequences if you're not doing them when FDA is in full enforcement mode. I can't import the product. I'm going to have really grumpy customers. My foreign suppliers are also probably going to be kind of grumpy. The other thing is they can take you to court. The Food, Drug, Cosmetic Act can be enforced through fun things like seizures. They can seize your goods. Or you can get an injunction from the Food and Drug Administration that prohibits you from importing food. You can be charged civilly and get that injunction. You can also be charged criminally for violating the Food, Drug, and Cosmetic Act. If if you want to like scare your friends in the food industry, and someday when I'm really bored, I'm tempted to write this letter. Technically, a simple misbranding, such as a net quantity statement that is too small, exposes you to criminal liability under the Food, Drug, and Cosmetic Act, because it is a prohibited act that can be enforced that way. So we have those enforcement mechanisms. Import refusals or judicial action. Judicial action is to be out there and to be noteworthy, but later we'll kind of talk about why the real focus is on that import refusal. So we have a law. We know what FDA can do to people if they don't comply. So that's the negative side. But how do they go about it? Because one of the things to think about here is because of the quality you have in your products and your brand, you want to have safe food and you want to do all of that. And that's right. The challenge here now is you have someone also grading you that you didn't before, the Food and Drug Administration. And so you need to be able to speak to the teacher who's grading you, the enforcement officer. So it's important to understand how FDA is going about enforcing this. So one of the rumors that goes around is people are really scared. Oh my goodness, my shipment's going to get stopped while FDA reviews my FSVP. We're going to have a shipment on the water, it's going to be stuck in port, and FDA's going to ask about it. The agency said that's not how we're going to do this. Our import exams, that random sampling and testing, is going to be separate from our FSVP reviews. Our FSVP reviews are going to be like a facility inspection. We're going to knock on the door, introduce ourselves. We're from the Food and Drug Administration. Issue a form called a 482, which says, hi, we have the authority to come to your office at reasonable hours and inspect you. And we don't need a court order to do that. And you must supply the documents. And so FDA has started and is ramping up these type inspections. They're knocking on importers' doors, their offices and the like, introducing themselves and saying, on June whatever, I saw you imported a shipment of chocolate from manufacturer X. Please provide your FSVP plan for that, where you approved them as your supplier. And then they're reviewing the records. So FDA has a pretty set process by which they review everything, whether we're talking FSVPs, whether we're talking about a warehouse and sanitation, whether we're talking about a food label. And they went to the grocery store and picked up a food label and thought about it. First, they're in investigation mode, gather the facts. What's going on? Now with the facility type inspection, they issue this form 482. Just introduce themselves and states their legal authority to be there. Now, if the inspection goes well, they wish you well, have a good day, and then you probably never hear from them again. If with foods, you'll get a closeout letter, Lord willing, weeks or months later that says, we inspected you, it went wonderfully, we have nothing further at this time. Hugs and kisses, the Food and Drug Administration. But say that inspection at your warehouse, at your office didn't go great with your FSVP. They issue what's called an FDA Form 483. And the reason why I'm boring you with form numbers is being mindful of the person who's grading your FSVP is the Food and Drug Administration. And so it's important to know how they talk, how they think, because that's who's grading you, as instructed by the Congress. And so Form 483 is the inspector's observations of non-compliance. What does the inspector think is not in compliance? And so when you look at the reports FDA's been putting out, there's a big trend right now of food importers that were inspected. And the comment is, you don't have an FSVP plan. You need one. And making that observation. Now, when FDA issues one of these forms, because the agency's goal is voluntary compliance, they would rather not have to go to full-on enforcement if you can come into compliance on your own, assuming there aren't bad after factors or recidivist factors. You have an opportunity to respond to that 483, where you can say, you're right, things weren't what they were supposed to be, so think of those, BRC, GFSI audits where you have your corrective actions after your auditor points something out. Similar to that, here you have a chance to cure, where you explain, we recognize we didn't have an FSVP for the supplier at that time. In the interim, we have instituted the program. Here is now the FSVP for that supplier, and we have a program in place for all others moving forward. And FDA reviews that as part of it. And if they find it adequate, they're happy they brought you back into compliance. And generally speaking, they move on. Now, it may be that you don't respond well to the 483, it's not good enough, or because of the egregious nature of it, FDA says we need to have a conversation that's a little bit stricter. And so they have things called regulatory meetings, untitled letters, which is a letter from FDA saying you have a problem, but it's private. They have what's called warning letters, which are public letters where they say, we inspected you or we reviewed your products and there are these non-compliance factors. Warning letters are public. They often get picked up in the food news pretty quickly and they directly impact you. As when you think about your FSVP, one of the things you're actually supposed to do is review that compliance history of the supplier. One of the variables to consider is, do they have any warning letters? And if they do, are they relevant and did they respond and are they still open? When you get those warning letters or those type of meetings, you want to make sure you have cured those problems or maybe disagree with the agency. These are opinions and they're points of conversation, but usually the FDA is only bringing them up because they think there's a problem that they're willing to go to the mat for. So far with FSVP, and so I've been talking generally FDA's not yet issued that first warning letter for FSVP. The agency knows that, and they said, it's coming. We haven't found out who we want to, because when the FDA issues a warning letter, it's as much as a warning to that company as it is to the whole industry. We think this is a problem. And so they're looking, my gut is, the first company that's going to get it is there will be a food safety recall or something went wrong on that front. They inspect that importer associated with the food and found the FSVP wanting. And that's likely the firm that's going to get the first warning letter. Because it's going to get a lot of press and the agency will likely point to say there is, in their opinion, a connection with unsafe food and the failure to do your due diligence. So we're still waiting to get that first one, but the agency's going to try and make a statement. And probably, my gut is it will happen in the next 18 months. When it will happen will depend on a lot of variables. And the last thing is, say you don't get your voluntary compliance in order, or something egregious happens. FDA goes into enforcement mode. They're seeking to punish you. One is import refusals. So I had my 483, didn't do my FSVP. They even sent me a letter. I said, I don't care, whatever, Food and Drug Administration. They can issue something called an import alert, where those future croissants I'm trying to import from James had mentioned, I'm now banned from importing them until I have convinced FDA I have an adequate FSVP in place and they are pleased with it. Until I have submitted that documentation and been reviewed by the agency, I'm still banned from being imported. Reviews like that, so we haven't seen the FSVP context, but we've seen it with, say, seafood HACCP, juice HACCP. Those reviews can take months or years because the agency's now really in your operations and going, is that really adequate? Did you really document that right? I'm not sure that was documented right. By the way, I see your foreign suppliers doing this. I'm not sure that's good enough. Could you provide more explanation on that point? Oh, by the way, I didn't like how you responded for that. So I'm going to close out your case file. You can come back and resubmit. And by the way, I'll get you a new case file number and you go to the back of the line because you weren't ready. And that process can get very iterative and very painful. So it's critical to be ready on the front end and to avoid getting into that loop. No one's there yet, but it will happen because FDA is doing it in other contexts. Last one is that judicial action. It will get mentioned. It's important to be mentioned. That's not likely where you'll see the FDA front, so let's not use that as our motivation to run and be scared. You need to be mindful of it. But FDA only brings about 12 to 15, 20 judicial cases for all regulated commodities a year. It's only the most egregious cases. The peanut farmers of America, where they were lying about salmonella and they knew it. Or if you remember the cantaloupes with Jensen Farms. FDA is making a very bold public statement when they're bringing it. They're going to look at that import refusals because that's enough of a hammer to keep you out of the market. But we don't want to be worrying about those as our motivation for compliance because compliance is critical, and a lot of times we won't have a customer if we don't have our own house in order because a lot of the down chain stuff is now looking at importers' FSVPs to make sure they're having control. But we need to be mindful of what can happen. And so remember, FSVP is not sitting in abstract anymore. It's part of the foundation. So CTPAC, we can talk about as a great system for decreased customs inspections. It helps get through the process. And Ron can talk ad nauseum about it and put me to shame because I've now maxed out my descriptive knowledge. FDA has something similar for food importers called VQuIP, the Voluntary Qualified Importer Program, where you have a solid FSVP plan. You have really vetted your foreign suppliers, but you're also going above and beyond, and you submitted all of this to FDA. And they say, yes, you are. And you get to go on a public list where FDA says, we think these guys are really got their house in order. You get increased access to the agency where if you're having import hold or having issues, you can talk to the agency more quickly. You have assigned individuals to help you. And if you have inspections, there's more leeway where the inspection will happen and the like. But you can only be in that program if you have a solid FSVP to begin with. The other thing is FSVP information will help direct foreign facilities inspections based on what they see with the importers. They look at my plan and say, you know what, maybe we do need to go visit a facility abroad because we have some questions. Or no, everything seems in order when we're looking at it. Let's put our resources elsewhere. Same with import detention holds. Well, let's start testing here because there seems to be something that we're seeing as we're looking at importers' verification programs. And the big thing to keep in mind is what's the punishment for non-compliance? It's ultimately those import refusals. And once you get them, there's no real your supply chain is dead, and there goes your company very quickly, because if you can't get supply, you're out of luck. So, again, here I'm just laying the foundation. This is what the law is, this is how the agency is thinking about it, this is how they're going to go about their business. Now comes the real challenges. Okay, what are the details of that reg, and how do I incorporate that into my operations so that I can have a smooth business of importing and selling food? Because I don't exist for the Food and Drug Administration to have things to inspect. I exist, not for my Reg Affairs department, as much as I personally love Reg Affairs departments, but to be importing and selling foods that consumers are really enjoying and finding nutritious and enjoyable. So we have to build those programs. And so this is just that initial foundation. So as I pull up my crystal ball, as we're thinking about the future and how you're designing your programs and understanding applications, these FDA inspections are going to continue. They did a few hundred the first year, then they've been into 1,000, and they're going to keep growing as FDA is really redirecting its resources to going into the importers' offices and understanding the foods and what controls are being put on abroad to better understand their resources. So the inspection core that used to go, say, to the warehouses and collect a sample from the shipment and then send it to the FDA lab, a lot of them are being retrained and redirected to FSVP inspections to put the resources there. And so now with what they learn from that, they're going to direct where they sample and test. But it's not like this is a fad that's going to happen and fade away. FDA is training and retooling its inspection core to do this and has a set just dedicated for it. These inspections are going to get more sophisticated. The when question is the $1 million question and probably will be varying over the next 10 years. So when I've talked thus far, it was just, hey, do you have an FSVP? Good. Thanks, bye. You don't have one? Bad. Okay, we're closing out the file, but we'll be back. Hey, we're closing out the file, we'll be back, that era is about over. It's now going to be, you don't have one? That's bad. How are you going to fix it now while I'm still talking to you? Those are going to go on for a couple of years. FDA is looking at this regulation like it has implemented other food safety regs, and it has a set pattern. Educate while you regulate, make sure people have the basics in order, start nitpicking it, and then really nitpick it, and then constantly improve. And so we're at the, hey, do they have it? Cool. At some point, it's going to start shifting. Hey, we see that you're importing this commodity, and you said, salmonella wasn't a hazard, and this is why. I don't agree with you. And guess who's the final arbiter? The Food and Drug Administration. I think you need one. And so we're going to start seeing that type of nitpicking. Then we'll say, oh, good, we agree on the hazards, but I see your control looks this way. I don't think that's good enough. I think the controls probably need to look this way. Or, just remember, you choose an appropriate verification based on the food hazards and the compliance profile. You choose one, verification and say, I think this is good enough. FDA could eventually come along and say, I don't think that's good enough. I think you need to be doing something like this and like this. Those are the tough questions that the regulations don't answer. The guidances don't yet answer. And if you corner the FDA experts, they don't know the answer yet, because that's going to be something that we're going to work out as the process moves along and gets implemented, and the agency sets its baseline expectations. So anything you're doing today, you need to be reevaluating constantly, because the interpretation of the law is going to keep evolving, and so being mindful of that. Then lastly, we're going to see that first warning letter at some point. And the contents is going to say you didn't have one, and you have to have one. And those warning letters are going to happen. And then you're going to, again, like we talked about, start to see a shift in them. You didn't identify all the appropriate hazards. We think this was one and you missed it. And then your control wasn't sufficient. If you want to get bored, you'll see that evolution in the seafood industry with HACCP. Similar, you didn't have it, hazards maybe, really don't like your control. And then it just keeps circling. And so that's it for now, kind of laying that foundation as we move forward into thinking about, okay, what does this mean for me and my operations, and how do I create a system that is not overly burdensome, that meets the objectives I need to, and ensures the quality and the safety of the foods that we import and distribute. So I'll open it up to questions, and here's my contact information. You'll get the slides as well. And I have a love of Pearls Before Swine, and if you read the comic, he's really sarcastic because he was an attorney before he became a cartoonist. So it comes out a lot.